powerful tool in estate planning. Life insurance is a contract between you and an insurance company. In exchange for regular premium payments, the insurance company pays a death benefit to your designated beneficiaries when you pass away. There are several types of life insurance, including term life, whole life, and universal life insurance. Life insurance can be a critical component of your estate plan, offering several key benefits. One of the primary benefits is providing liquidity. When you pass away, your estate may need immediate funds to cover various expenses, such as funeral costs, outstanding debts, and administration fees. Life insurance provides a source of immediate cash, which can help your family cover these expenses without having to sell assets or borrow money. Another significant use of life insurance is paying estate taxes. Depending on the size of your estate and the applicable laws, your estate may be subject to federal and state taxes. These taxes can be substantial and may need to be paid within a relatively short period after your death. Life insurance proceeds can be used to cover these tax liabilities, ensuring that your heirs receive their inheritance without having to liquidate assets to pay the taxes. Let's look at some specific ways life insurance can be used in estate planning. First, funding buy-sell agreements. If you own a business, a buy-sell agreement is a crucial part of your succession plan. This agreement outlines how a partner's share of the business will be handled if they pass away. Life insurance can fund these agreements by providing the necessary cash to buy out the deceased partner's share, ensuring a smooth transition and continuity of the business. Second, equalizing inheritances. If you have multiple heirs and not all of them are involved in the family business or other substantial assets, life insurance can provide a way to equalize inheritances. You can leave the business to the heirs who are involved and use life insurance proceeds to provide an equivalent value to the other heirs, ensuring that everyone is treated fairly. Third, covering final expenses. Life insurance can help cover the costs of your funeral, outstanding debts, and other final expenses. This relieves your family of the financial burden and allows them to focus on grieving and healing. Fourth, providing for minor children. Life insurance can ensure that your young dependents are financially secure. The proceeds can be used to cover their living expenses, education costs, and other needs until they reach adulthood. There are several benefits to using life insurance in estate planning. Life insurance proceeds are generally tax-free for the beneficiaries, providing a tax-efficient way to transfer wealth. Additionally, life insurance offers flexibility and control over the distribution of assets, allowing you to tailor your plan to meet your specific goals. Knowing that your loved ones will be taken care of can provide peace of mind. Setting up life insurance for estate planning involves careful consideration and planning. It's important to work with a qualified estate planning attorney and financial advisor to determine the right type and amount of coverage for your needs. They can help you choose the appropriate policy, designate beneficiaries correctly, and integrate life insurance into your overall estate plan. In summary, life insurance is a versatile and valuable tool in estate planning. It provides liquidity to cover immediate expenses, helps pay estate taxes, funds buy-sell agreements, equalizes inheritances, covers final expenses, and provides for minor children. By incorporating life insurance into your estate plan, you can ensure the financial security of your loved ones and the smooth transition of your assets. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney or financial advisor. See you in the next video.
Some people believe that wills are only necessary for the very wealthy or those with complicated assets. However, there are many good reasons to have a will. You can be clear about who gets your assets. You have more control and can decide who gets what and how much. Your heirs will be able to access your assets more quickly and easily. Additionally, with proper planning, you can plan to save your estate money on taxes. You can also give gifts and charitable donations, which can give tax benefits. However, even if you have a will, upon your passing, your assets will be routed through the probate process. Probate is the legal process that occurs to your estate after you pass away. This is a court-monitored process where the debts of the estate are paid and distribution is made to the heirs. The probate process will flow smoother with a will. Probate costs money and can take significant time. With proper estate planning, probate may be able to be avoided. Trusts can accomplish the same goals as a will, but oftentimes in much better fashion. When a trust is properly set up, it can avoid probate entirely. Any assets that belong to the trust will not be routed through probate. Often, a type of will, a pour-over will, is used in conjunction with creating a trust to ensure all assets are covered, even if they are not properly moved to a trust. To ensure your will or trust is done properly, contact Heritage Law Office today.
Think a will is enough? Here's why a living trust might be the smarter move. First, living trusts avoid probate. Unlike a will, a living trust keeps your assets out of court. That means faster transfer to your loved ones and no costly probate fees. Second, living trusts provide privacy. Wills become public record, but trusts stay private. Your family matters, stay your family's business. Third, living trusts have flexibility. It's called living because you can change it any time while you're alive. Update it as life changes. And fourth, living trusts provide continuity. If you become incapacitated, your trustee can step in immediately, with no court delays. Bottom line, a living trust saves time, money, and stress for your family. Want more estate planning information? Hit subscribe.
Most parents think they're being smart when they add their child's name to their property deed. They believe it's a simple way to avoid probate, save on taxes, or just make things easier when they're gone. But here's the harsh reality that real estate attorneys see every single day. This well-intentioned decision can absolutely destroy your family's financial future. We can tell you that some of
In this video, we will discuss how to amend a living trust, including the reasons for making amendments and the steps involved in the process. A living trust, also known as a revocable trust, is a legal document created during a person's lifetime that designates a trustee to manage the individual's assets for the benefit of the beneficiaries. One of the main advantages of a living trust is that it allows for the easy transfer of assets without the need for probate. There are several common reasons why you might need to amend a living trust. You may need to add or remove beneficiaries due to marriage, birth of children, or death. You might want to appoint a new trustee or successor trustee. Perhaps you need to modify how the assets are distributed among beneficiaries. Or you could be adding newly acquired assets to the trust. Changes in personal circumstances, such as marital status, financial status, or health conditions, can also necessitate amendments. To amend a living trust, follow these steps. First, review your original living trust document to understand its provisions and identify the sections that need changes. Next, decide on the type of amendment. There are two primary methods: a trust amendment for minor changes or a restatement of the entire trust for major changes or multiple amendments. Then, draft the amendment. Clearly title the document as an amendment to the living trust, specify the date of the original trust and the date of the amendment, detail the specific changes being made, and include a clause reaffirming the unchanged portions of the trust. Sign and notarize the amendment. Both the grantor and the trustee, if different from the grantor, should sign the document in the presence of a notary public. Attach the amendment to the original trust document to ensure all parts of the trust are easily accessible and legally recognized. Finally, notify all relevant parties, including trustees, beneficiaries, and financial institutions, of the changes to the trust. When amending a living trust, it's important to maintain consistency in the document to avoid any confusion and potential legal disputes. Consider how the amendment might affect your estate taxes and consult with a tax advisor if necessary. If you amend your living trust, you may also need to update related estate planning documents such as wills, powers of attorney, and beneficiary designations. When changing successor trustees, choose someone you trust to manage your assets responsibly. In summary, amending a living trust involves reviewing the document, deciding on the type of amendment, drafting the changes, signing and notarizing, attaching the amendment to the original trust, and notifying relevant parties. While it's possible to amend a living trust on your own, consulting with an experienced attorney is highly recommended to ensure that the amendments are legally valid and correctly executed. An attorney can provide guidance tailored to your specific situation and help avoid common pitfalls. In this video, we will explore how trusts play a crucial role in business succession planning. If you're looking to ensure the smooth transfer of your business to the next generation, stay tuned. Business succession planning is essential for the longevity and stability of a business. Trusts are a powerful tool in this process, helping manage and transfer business assets effectively. So, what exactly is a trust? A trust is a legal arrangement where one party, known as the trustee, holds and manages assets for the benefit of another party, the beneficiary. Trusts can provide several advantages in business succession, such as maintaining control over assets, offering tax efficiency, protecting against creditors, and ensuring continuity and stability. There are various types of trusts used in business succession planning. Let's briefly discuss some of the most common ones. Revocable trusts allow the business owner to retain control over the trust assets during their lifetime and make changes as needed. This type of trust can avoid probate, ensuring a smooth transition of assets to the beneficiaries upon the owner's death. Irrevocable trusts, on the other hand, cannot be modified or revoked once established. These trusts provide significant tax benefits by removing assets from the owner's taxable estate and offering protection against creditors and lawsuits. Testamentary trusts are created through a will and become effective upon the owner's death. They allow detailed instructions for asset management after death but require probate before becoming effective. Charitable trusts are designed to benefit a charitable organization while providing tax benefits to the business owner. These trusts can ensure that a portion of the business assets supports charitable causes. Using trusts in business succession planning offers several strategic benefits. Trusts can help avoid the lengthy and costly probate process, maintain confidentiality, ensure business continuity, provide flexibility in asset distribution, minimize family disputes, and protect beneficiaries. To implement a trust in your business succession plan, follow these steps. First, assess your business and personal goals. Determine your objectives for the succession plan and identify key individuals involved in your business. Next, consult with an experienced attorney to explore your options and create a tailored plan. Choosing the right type of trust is crucial, as it should align with your goals and provide the desired benefits. Draft the trust document, clearly outlining the terms and conditions, as well as the roles and responsibilities of the trustee and beneficiaries. Then, fund the trust by transferring ownership of the business assets into it. Communicate the plan to key stakeholders, including family members and business partners, to ensure a smooth transition. Regularly review and update the trust to reflect changes in business or personal circumstances. Consider the example of a family-owned manufacturing business. The owner, nearing retirement, established a revocable trust to transfer ownership to their children. The trust included specific instructions on management roles and profit distribution. By doing so, the owner ensured a clear management structure, tax efficiency, and continued business growth under the new management. In summary, incorporating trusts into your business succession plan can provide numerous benefits, including control, tax efficiency, and asset protection. To secure the future of your business, consult with a professional attorney and develop a well-structured trust plan today. Thank you for watching. If you found this video helpful, please like and subscribe for more content on business succession planning. In this video, we will explore the benefits and process of buying property through a trust. A trust is a legal arrangement where one party, known as the trustee, holds property for the benefit of another party, known as the beneficiary. Trusts can be used for various purposes, including estate planning, asset protection, and privacy. One of the main benefits of buying property through a trust is asset protection. Properties held in a trust can be shielded from creditors' claims and lawsuits. Additionally, trusts offer privacy by keeping ownership details out of public records. When it comes to estate planning, trusts allow for the efficient transfer of assets upon the owner's death, avoiding the lengthy and costly probate process. Trusts also provide control over how and when assets are distributed to beneficiaries. Properly structured trusts can offer significant tax benefits, reducing estate taxes and providing other tax advantages. Several types of trusts can be used for buying property. A revocable trust allows the grantor to retain control and make changes to the trust. This type of trust is ideal for estate planning and can simplify the transfer of property after death. An irrevocable trust, once established, cannot be altered or revoked. This type of trust provides stronger asset protection and potential tax benefits. Charitable trusts allow property owners to support charitable causes while receiving tax benefits. Special needs trusts are designed to provide for beneficiaries with special needs without affecting their eligibility for government benefits. Now, let's go through the steps to buy property through a trust. First, establish the trust with the help of an experienced attorney. This involves drafting the trust document and naming the trustee and beneficiaries. Next, find a suitable property that aligns with your investment goals and the terms of the trust. If financing is needed, work with lenders who are familiar with lending to trusts. Ensure the property is titled in the name of the trust, not the individual, to maintain the legal protections and benefits of the trust structure. Once the property is purchased, the trustee will manage it according to the trust terms, ensuring that all obligations, such as taxes and maintenance, are met. Trustee duties include managing trust assets, maintaining the property, keeping up with property taxes and insurance, and acting in the best interests of the beneficiaries. Trustees must also keep detailed records and provide regular reports to the beneficiaries. Beneficiaries have the right to access trust documents, receive regular updates, and receive distributions as specified in the trust document. They must comply with the terms and conditions outlined in the trust and stay informed about the trust's activities. Key considerations for buying property through a trust include understanding the legal and tax implications. Trust laws can vary by state, so it's important to ensure compliance with local regulations. Engage an experienced attorney to navigate the complexities of setting up and managing a trust. Practical steps for trust management include regular property inspections, creating a budget for property expenses, and developing a prudent investment strategy for any income generated by the property. In summary, buying property through a trust offers significant benefits, including asset protection, privacy, estate planning advantages, and tax benefits. However, it requires careful planning and management. Consider seeking professional advice to ensure your real estate investments are secure, efficiently managed, and aligned with your long-term goals.
So you want to put your home into a trust? It's easier than you think. Here's how to do it in 3 steps. Step 1. Gather all your property documents and trust paperwork. You need to know what you're working with before you start. Step 2. Choose the right type of trust for your needs. Revocable, irrevocable. Pick what suits you best. Final step. Transfer the title of your home into the trust. Just like that, your home is protected and secure. Want more? Follow for more estate planning videos.
Probate is the legal process that occurs to your estate after you pass away. During this legal process, a court will monitor the process of paying your debts and distributing your estate to the proper heirs. The probate process will take several months at minimum to complete and may take longer, depending on the complexity of your estate. Through proper planning, probate can be avoided, saving time and money. Tools such as a trust, life estate, joint ownership, and payable or transfer on death designations may be able to avoid probate. A will does not avoid probate as it is designed to go through the probate process. Speak to a professional today. In this video, we will discuss what a trust is and how it works. A trust is a legal arrangement where one party, known as the grantor, transfers assets to another party, called the trustee. The trustee holds and manages these assets for the benefit of a third party, known as the beneficiary. There are several types of trusts, each serving different purposes. The most common types are revocable trusts and irrevocable trusts. A revocable trust can be altered or revoked by the grantor during their lifetime. This flexibility allows you to make changes as your circumstances or intentions evolve, making it an excellent choice for those who want to retain control over their assets. An irrevocable trust, on the other hand, cannot be easily changed once it is established. This type of trust can provide significant tax advantages and protect assets from creditors, making it ideal for those looking to secure their wealth for future generations. Special purpose trusts are designed for specific goals. Let's look at some common examples. A charitable trust can help you support a cause you care about while potentially offering tax benefits. A special needs trust can provide for a loved one with disabilities without jeopardizing their eligibility for government benefits. A spendthrift trust is useful for protecting a beneficiary who may not be financially responsible. A Medicaid Asset Protection Trust helps individuals qualify for Medicaid while protecting their assets. A testamentary trust is established through a will and goes into effect upon the grantor's death. An asset protection trust is designed to protect your assets from creditors. Creating a trust involves drafting a legal document that outlines the terms of the trust and appointing a trustee. Once established, the grantor transfers assets into the trust, which the trustee then manages according to the trust's terms. The trustee has a fiduciary duty to act in the best interests of the beneficiaries, ensuring the assets are managed and distributed as specified in the trust document. Using a trust offers several benefits. It can help avoid the lengthy and public probate process, ensuring a quicker and more private transfer of assets. Trusts also provide greater control over how and when assets are distributed, which can be particularly useful for beneficiaries who are minors or have specific needs. Additionally, certain types of trusts may offer tax advantages, potentially reducing the overall tax burden on the estate. In summary, trusts are versatile legal tools that can provide significant benefits in estate planning. Have you ever wondered what happens to someone's assets after they pass away? Today, we'll explore the world of probate, breaking it down into steps, as well as looking into the various types that are most appropriate depending on your circumstances. Dealing with assets after a loved one's passing is never easy, but understanding the process can help. Let's break down probate. What is probate? Probate is the formal legal procedure after someone's death, which settles their financial and legal affairs. It is the process that ensures assets are transferred rightly and legally to beneficiaries, and any outstanding debts are settled. But who ensures this process runs smoothly? The crucial role of the executor, that would be the executor, also known as the personal representative. They initiate the probate process, manage assets, settle debts, and ensure the rightful distribution of assets. It's a significant role, oftentimes demanding guidance from experienced probate attorneys. But how do you get started with probate? Let's walk through it step by step. Step 1. Initiating the probate process. Everything begins with appointing a personal representative, either named in the will or chosen by the court. They file a petition for probate, and here, professional legal guidance can be invaluable. Step 2. Inventorying the estate. The representative then takes stock of the deceased's assets, everything from real estate to bank accounts. Step 3. Settling debts and taxes. Before beneficiaries get anything, all debts and taxes must be settled using the estate's assets. Step 4. Distribution. Finally, the remaining assets are distributed according to the will or state laws if there's no will in place. Probate isn't one size fits all. There are different types for varying circumstances. Types of probate. Formal probate. This structured, judge-overseen process is ideal for complex estates or when beneficiaries have disputes. Informal probate. A simpler, quicker process fit for straightforward estates with a valid will and no disputes. Special administration. This method is for when immediate action is required or when full estate administration isn't necessary. Probate may seem complex, but with experienced guidance, you can be sure your estate is managed properly. Be sure to check out additional articles on probate or inquire about a consultation on the Heritage Law Office website in the description below. Also, don't forget to subscribe to the channel for more helpful legal content, and please hit that like button.
Your home is paid off. Your retirement accounts are healthy. You're living the American dream. Then it happens. A stroke. A fall. Alzheimer's creeping in like fog over a harbor. Suddenly, you need round-the-clock care and the bill. Try $120,000 a year, every single year. That's $10,000 a month disappearing from everything you've built. Within 3 years, your life savings are gone. Your spouse is left scrambling, potentially facing poverty after a lifetime of financial responsibility. Your children watch helplessly as their inheritance, meant to secure their own retirements, evaporates into the healthcare system. This isn't a nightmare scenario. This is Tuesday afternoon in America for thousands of families. The truth is, nursing home costs aren't just expensive. They're catastrophic. We're talking about an industry that has turned elder care into a wealth extraction machine. And here's the kicker. Medicare covers almost nothing. Medicaid will help, but only after you've spent down nearly every asset you own. You're essentially required to become impoverished before the safety net kicks in. But what if I told you there are completely legal strategies that savvy families use to protect their assets while still qualifying for benefits? What if there were ways to ensure your spouse doesn't end up destitute, and your children aren't forced to choose between their own financial security and your care? Today, I'm going to walk you through the exact methods that estate planning attorneys use for their own families. The strategies that the wealthy have been quietly employing for decades while middle-class America gets financially decimated by long-term care costs. We'll explore everything from the 5-year look-back period to sophisticated trust structures that can shield millions in assets. This isn't about gaming the system or committing fraud. These are legitimate, court-tested strategies that Congress specifically allows because they recognize that impoverishing families shouldn't be the price of growing old in America. Let's start with the brutal mathematics of nursing home costs, because understanding the scope of this threat is crucial to appreciating why asset protection isn't just smart, it's essential. The average cost of a private room in a nursing home has skyrocketed to over $120,000 annually. In high-cost areas like New York or California, you're looking at $150,000 to $200,000 per year. That's more than most people's entire annual income, and it's due every month regardless of the quality of care. Memory care facilities, which many Alzheimer's patients require, can cost even more. We're talking $180,000 to $250,000 annually for specialized dementia care. And here's what really stings. The average nursing home stay is 2.4 years, but that's just an average. 20% of residents stay 5 years or longer. Some families face a decade or more of these crushing expenses. Do the math. Even at the national average, a 3-year stay costs $360,000. A 5-year stay? $600,000. These numbers aren't theoretical. They're the financial reality facing 1.3 million Americans currently living in nursing homes, with 10,000 baby boomers turning 65 every single day. Medicare, the program most people assume will cover their long-term care, provides virtually no help. It covers skilled nursing care for a maximum of 100 days, and only if you meet strict criteria about being hospitalized first and requiring skilled medical care, not just custodial care. Most nursing home residents need custodial care, help with bathing, dressing, eating, basic daily activities. Medicare doesn't cover that at all. So families face a choice: pay out of pocket until you're broke, or spend down your assets to qualify for Medicaid. This spend-down process is where most families make critical mistakes that cost them hundreds of thousands of dollars unnecessarily. Medicaid will cover nursing home costs, but there's a catch. You can only keep $2,000 in countable assets. Your house might be protected while you're alive, but Medicaid has the right to recover costs from your estate after death. Your retirement accounts, your savings, your investments, all of it must be liquidated to pay for care before Medicaid steps in. For married couples, the rules are slightly more generous, but still devastating. The community spouse, the one still living at home, can keep approximately $150,000 in assets. Everything above those limits must be spent on the nursing home spouse's care. Imagine working for 40 years, building a $800,000 nest egg, only to watch $650,000 of it disappear into nursing home payments. But here's where it gets interesting. Medicaid has what's called a 5-year look-back period. Any gifts or asset transfers made within 5 years of applying for benefits are scrutinized. Make an improper transfer, and you face a penalty period where you're ineligible for benefits. This is where most families panic and make expensive mistakes. However, and this is crucial, there are numerous exceptions and strategies that allow for proper asset protection even within this look-back period. The key is understanding what Medicaid considers a legitimate transfer versus what triggers penalties. Transfers to certain types of trusts, purchases of exempt assets, and specific gifting strategies can all be done legally and effectively. The wealthy figured this out long ago. They don't lose sleep over nursing home costs because their estate planning attorneys have structured their assets properly. They use irrevocable trusts, strategic gifting programs, and asset repositioning techniques that keep their wealth protected while still qualifying for benefits when needed. The middle class, meanwhile, typically gets advice that sounds something like this: well, you'll just have to spend down your assets until you qualify for Medicaid. That's not advice, that's surrender, and it's completely unnecessary if you understand the rules and plan accordingly. What we're about to explore are the specific strategies that can protect your assets legally and ethically. From simple techniques that anyone can implement to sophisticated trust structures for larger estates, there are options available at every wealth level. The key is understanding the rules, timing your moves correctly, and avoiding the common pitfalls that trap unprepared families. Because here's the truth they don't want you to know. Asset protection from nursing home costs isn't about being wealthy. It's about being informed. The first and most accessible strategy in your asset protection toolkit is understanding exempt assets. These are resources that Medicaid cannot touch, regardless of their value. Your primary residence is an example of an exempt asset, protected in most states. But here's what most people don't realize. You can actually increase this protection by making strategic home improvements or paying down your mortgage with countable assets. Think about it. If you have $100,000 sitting in a savings account, that's a countable asset that must be spent down. But if you use that same money to renovate your kitchen, add a bathroom, or install a new roof, you've just converted countable assets into exempt assets. The value is still there, it's just protected now. This isn't hiding money. This is smart repositioning. Your car is another exempt asset, but only one vehicle per household. Families have legitimately purchased $80,000 luxury vehicles or specially equipped vans and had them considered exempt assets. Again, you're not losing the value. You're converting it into a protected form. However, after you pass away, Medicaid will attempt to recover assets from your estate for any expenses they paid on your behalf. This means they may be able to recover your house or car. To solve this, let's move beyond basic exempt assets and talk about more sophisticated strategies. The irrevocable trust is perhaps the most powerful tool in the asset protection arsenal. When properly structured, these trusts can protect unlimited assets from nursing home costs while still providing some benefits to the person who created them. Here's how it works. You transfer assets into an irrevocable trust, typically naming your children or other beneficiaries as the ultimate recipients. The trust is structured so that you retain certain limited rights, perhaps the right to live in your home if it's transferred to the trust, or the right to receive income from investments held by the trust. The key is that you no longer own these assets outright, so they're not counted for Medicaid purposes. The catch? This strategy requires advanced planning. Remember that 5-year look-back period. Any assets transferred to an irrevocable trust must be done at least 5 years before applying for Medicaid benefits. That's why this isn't a crisis planning technique. It's a long-term strategy that requires foresight and commitment. But what if you're already facing an immediate need for long-term care? What if that 5-year window has closed? Don't despair. There are still powerful strategies available, though they require more sophisticated planning and often professional guidance. The Medicaid-compliant annuity is one such technique. By converting countable assets into an income stream through a specially structured annuity, you can often protect significant wealth while still qualifying for benefits. The annuity must meet specific requirements. It must be immediate, irrevocable, and actuarially sound. But when done correctly, it can preserve hundreds of thousands of dollars. For married couples, the strategies become even more nuanced and powerful. The Community Spouse Resource Allowance allows the at-home spouse to retain approximately $150,000 in assets. But through a technique called spousal refusal, the community spouse can actually refuse to contribute their assets to the nursing home spouse's care. This creates a fascinating dynamic where the nursing home spouse can qualify for Medicaid while the community spouse retains significantly more assets. Asset purchase strategies offer another avenue for protection. Instead of simply spending down assets on nursing home care, families can purchase items that are either exempt or provide ongoing value. Prepaying funeral expenses, buying a more expensive home in a state with higher homestead exemptions, or purchasing certain types of life insurance can all serve as effective spend-down strategies that preserve value for the family. The key to all of these strategies is understanding that Medicaid planning isn't about impoverishment. It's about reorganization. You're not making assets disappear. You're restructuring them in ways that comply with Medicaid rules while still providing maximum benefit to your family. Geographic arbitrage plays a role too. Some states are far more generous in their Medicaid rules than others. The homestead exemption varies dramatically by state. Income and asset limits differ. Even the rules around trust protection vary significantly. Families sometimes relocate strategically to take advantage of more favorable Medicaid rules in their new state of residence. But perhaps the most overlooked strategy is the proper use of caregiver agreements. When adult children provide care for aging parents, this care has real economic value. A properly structured caregiver agreement allows families to compensate adult children for this care, effectively transferring assets while receiving legitimate services in return. The key is documenting the arrangement properly and ensuring the compensation is reasonable for the services provided. Finally, these strategies can often be used together to create a plan that works for your situation. The mistake most families make is waiting until crisis hits before exploring these options. By then, many of the most powerful strategies are no longer available. The 5-year look-back period means that effective asset protection requires the kind of advanced planning that most people resist because it forces them to confront uncomfortable realities about aging and long-term care. While you can still protect a portion of your assets if there was no plan when a crisis hit, planning ahead at least 5 years gives you the biggest opportunity to protect the most amount of assets. This is where the wealthy have always had an advantage. They plan early, they plan comprehensively, and they work with professionals who understand these complex rules. But these strategies aren't reserved for the ultra-rich. Middle-class families can implement many of these same techniques with proper guidance and sufficient lead time. The question isn't whether you'll face long-term care costs. The statistics are clear. Most of us will need some form of extended care before we die. The question is whether you'll face those costs with a plan that protects your family's financial security, or whether you'll join the millions of Americans who watch their life savings disappear into the healthcare system. So there you have it. The roadmap that separates families who preserve their wealth from those who watch it vanish into the nursing home abyss. From exempt asset strategies and irrevocable trusts to caregiver agreements and geographic planning, these aren't just theoretical concepts. They're the actual tools that informed families use to navigate the brutal mathematics of long-term care without sacrificing everything they've built. Remember, this isn't about gaming the system. It's about understanding rules that were specifically designed to prevent the complete impoverishment of American families. The wealthy have been using these strategies for decades, while middle-class America gets steamrolled by costs they never saw coming. The clock is ticking on your planning window. Every day you wait is another day closer to that 5-year look-back period that could lock you out of your best options. Don't be the family that discovers these strategies exist only after it's too late to implement them. Your life savings don't have to become a casualty of growing old in America. With proper planning, the right strategies, and sufficient lead time, you can protect what you've built while still ensuring quality care when you need it. The choice is yours, but the time to make it is now. Thanks for joining me today. If this opened your eyes to possibilities you didn't know existed, share it with someone who needs to hear this message. Because in the end, financial security in retirement isn't about luck. It's about knowledge, and knowledge shared is power multiplied.
Are you confused about estate planning terms? Stay tuned because we're about to simplify them for you. If you find this information helpful, make sure to subscribe to our channel for more tips on estate planning. What is a will? Let's dive right into it. A will is a legal document that outlines how your assets will be distributed after your death. It's a crucial part of estate planning because it ensures that your property is distributed according to your wishes. Additionally, if you have minor children, a will can specify who will take care of them. In summary, a will is essential for outlining how your assets are distributed and who will take care of your minor children. Next up, what is a trust? A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. There are two main types of trusts: revocable and irrevocable. A revocable trust can be altered or terminated by the grantor during their lifetime, while an irrevocable trust generally cannot be changed once it's established. People often set up trusts to avoid probate, reduce estate taxes, and manage their assets during their lifetime and beyond. Power of attorney. Have you ever wondered what a power of attorney is? A power of attorney is a legal document that grants someone else the authority to act on your behalf in financial or legal matters. This person is known as your agent or attorney, in fact. There are different types of powers of attorney, including a durable power of attorney, which remains in effect if you become incapacitated, a springing power of attorney, which comes into effect upon certain circumstances, a financial power of attorney, which specifically covers financial decisions, and a medical power of attorney, which specifically covers medical decisions. Now, let's talk about beneficiary designation. A beneficiary designation is a legal mechanism for naming individuals or entities to receive certain assets upon your death. Common assets that have beneficiary designations include life insurance policies, retirement accounts, and bank accounts. Beneficiary designations are important because they can override your will, so it's crucial to keep them up to date. Healthcare directive. Finally, what is a healthcare directive? A healthcare directive, also known as a living will or advance directive, is a legal document that specifies your wishes regarding medical treatment if you become unable to communicate those decisions yourself. It typically includes instructions on life-sustaining treatments and end-of-life care. Having a healthcare directive ensures that your medical care preferences are known and respected. These are just a few key estate planning terms, but they form the foundation of a comprehensive estate plan. Understanding these terms can help you take control of your future and protect your loved ones. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
Whether you're trying to avoid probate, protect your assets, or plan for your family's future, understanding trusts could save you thousands of dollars and months of headaches. But here's the thing most people get wrong about trusts. There are actually 3 simple steps to transfer your house into a trust, and we're going to break down each one so clearly that you'll wonder why you ever thought it was complicated. Plus, we'll reveal the one mistake that could completely invalidate your trust that many people make. First, you need to create the trust document itself. This isn't just filling out some random form online. The trust document establishes who controls the property, who benefits from it, and what happens when you're no longer around. You'll need to decide between a revocable living trust, which you can change anytime, or an irrevocable trust, which offers stronger asset protection but can't be modified easily. Next comes the actual property transfer. This means preparing a new deed that transfers ownership from your name to the trust's name. The deed must be properly notarized and recorded with your local county recorder's office. Without this step, your house never actually enters the trust, no matter what paperwork you've signed. Finally, you'll need to update all related documents and accounts. This includes homeowners' insurance policies, property tax records, and any existing mortgages. Many people forget this crucial step and end up with coverage gaps or compliance issues. The bottom line is this: transferring your house to a trust isn't rocket science, but it does require attention to detail and proper execution to protect what matters most.
Here's a number that surprises most people. Roughly 2 out of 3 Americans die without a will. They don't intend to, they just never get around to it, and then it's too late. And when that happens, the state steps in and decides who gets everything you built. Not you, not your family, the state. What I'm about to walk you through is what actually happens to your home, your savings, and your kids if you die without a will. It's not what most people expect. And once you hear it, you'll understand why this is the most important paperwork you'll ever sign. So let's start with the basic question. If you die without a will, what happens to your stuff? Here's the honest answer. Your stuff doesn't just disappear, it goes to court. A process called probate. The state appoints someone to take an inventory of everything you own, pay your debts and taxes, and then distribute what's left. But here's the catch. The state isn't distributing your assets according to what you would have wanted. It's distributing them according to a rigid, one-size-fits-all formula called the laws of intestacy, which literally means dying without a will. And that formula often does not match what a real family would choose. Your stepchildren, your close friends, the charities you cared about, your long-term partner if you never married, under this formula, they may get nothing at all. Let's make this concrete, because this is where it gets personal. Say you own a home and have a life insurance payout sitting in savings, and you pass without a will. If you're married, your spouse doesn't automatically get everything. In many states, they get a share, and the rest is carved up among your children. If you have kids from a previous marriage, the state may divide your home between your new spouse and those children, creating a situation where your spouse must either buy out your kids, sell the family home, or share it with people they may not get along with. If you're unmarried but living with a partner, a very common situation, Your partner inherits nothing unless the property is titled in both names. The entire estate may go to blood relatives you haven't spoken to in years. And if you have no relatives at all, the state can claim your entire estate. Everything you worked for goes to the government. Here's the part that keeps estate attorneys up at night, and it's the reason this video exists. If you die without a will and you have minor children, you have not named a guardian. That decision, who raises your kids if you're gone, does not get made by you. It gets made by a judge. The judge will consider family members, and sometimes the state will place your children with someone you would never have chosen. Your child's future is decided by a stranger in a courtroom, based on a formula, not on your wishes. You named a guardian in your mind 1,000 times, maybe your sister, maybe your best friend, but in your mind is not a legal document. If it's not written down, it doesn't exist. This is the single most important reason to have a will, not for your money, for your children. A will is the only document that lets you choose who raises them. So by now you might be thinking, fine, I'll get a will. And you should. But here's the honest truth. A will is the foundation, not the whole house. A will does 3 essential things. It names your executor, it names a guardian for your kids, and it says who gets your assets. It's one of the most important documents you'll ever sign. But it does not automatically protect your home from nursing home costs. It does not automatically avoid probate. And it does not handle the 3 biggest threats to everything you've built. That's what this series is about. Over the next few videos, I'm going to show you the specific legal tools that protect your home and savings from the 3 things that drain family estates: nursing home costs, probate fees, and family conflict. You're watching video 1, the foundation. Get the will right, and the rest of the structure has somewhere to stand. Here's the thing I need you to hear, and I'll say it plainly. The best time to do this was years ago. The second best time is this week. I know it feels like a task for someday, but I've seen too many families learn the hard way that someday doesn't wait. The health crisis that lands you in a nursing home doesn't check your to-do list first. It doesn't wait until you've drafted your documents. It arrives on its own schedule, and if your plan isn't in place, it's too late for the tools that require planning in advance. That's the uncomfortable truth about estate planning. The most powerful protections, the ones that shield your home from the nursing home, the ones that keep your savings out of probate, have to be set up while you're healthy. Not in the middle of a crisis, before. So here's what I want you to take away. Without a will, the state decides who gets your home, your savings, and your kids. 2 out of 3 Americans never write one, and their families pay the price in court fees, conflict, and lost control. But a will is just the foundation. The real protection for your home and your life savings comes from the tools I'm going to show you next. If you want to make sure your family is protected, the first step is a conversation. Reach out to an attorney. Subscribe and turn on notifications so you don't miss the next video.
Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are 2 primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The franchise agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind. initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video.
Join us as we take on the challenge of organizing the essential documents needed for a comprehensive estate plan and learn how to avoid costly mistakes along the way. Estate planning is often viewed as a complex and daunting task, but having a comprehensive plan in place can provide peace of mind and financial security for you and your loved ones. If you don't have a proper estate plan in place, your family may be left to deal with the fallout, which can lead to lengthy and costly probate battles, family disputes, and even financial devastation. Without a clear plan, your assets may not be distributed according to your wishes, and your loved ones may be left with a huge mess to sort out. In addition, if you become incapacitated, your family may have to go to court to get a conservatorship, which can be a lengthy and expensive process. Furthermore, your medical wishes may not be respected, and your family may have to make difficult decisions on your behalf without knowing what you would have wanted. Moreover, without a comprehensive estate plan, your business and personal assets may not be protected, leaving them vulnerable to creditors, lawsuits, and other risks. In the worst-case scenario, not having a proper estate plan can lead to family feuds, lawsuits, and even financial ruin. It's a heavy burden to place on your loved ones, and it's one that can be easily avoided with a little planning and foresight. A comprehensive estate plan consists of several essential documents that work together to protect your assets and ensure your wishes are carried out. These documents include wills, trusts, powers of attorney, and healthcare directives. Each document plays a vital role in ensuring that your assets are distributed according to your wishes, your loved ones are protected, and your medical wishes are respected. A will is a legal document that outlines how you want your assets to be distributed after you pass away. It's a crucial document that ensures your wishes are carried out, and it can also appoint guardians for minor children. Trusts, on the other hand, are legal arrangements that allow you to transfer assets to beneficiaries while minimizing taxes and avoiding probate. Powers of attorney give someone the authority to make financial and medical decisions on your behalf if you become incapacitated. Healthcare directives, also known as living wills, outline your medical wishes if you're unable to communicate them yourself. Each of these documents is essential to a comprehensive estate plan, and they work together to provide a complete picture of your wishes and intentions. By having all of these documents in place, you can ensure that your loved ones are protected, your assets are distributed according to your wishes, and your medical wishes are respected. It's a vital step in planning for the future and avoiding costly mistakes. By having a comprehensive estate plan in place, you can rest easy knowing that your loved ones will be protected and your wishes will be carried out. If you don't already have a comprehensive estate plan in place, we encourage you to take the first step and schedule a consultation with an estate planning attorney today. It's a small step that can provide huge peace of mind and financial security for you and your loved ones.
Titles and deeds play a pivotal role in legally recognizing and transferring property ownership. Join us as we break it down. What is a title? A title represents legal ownership of a property. It's the evidence that proves you have the right to possess, use, and control a piece of real estate. But what happens when you want to transfer that ownership? The importance of the deed. A deed is the legal document that conveys ownership from one party to another. Think of it as the passport for property, transferring the title and its associated rights. So, how does a typical transfer process look? Time to break it down. Understanding the transfer process. Step 1. Drafting the deed. A deed must include the grantor's and grantee's details, a description of the property, and the type of deed being executed. Step 2. Signature and notarization. The deed is signed by the grantor and often requires notarization for it to be legally valid. Step 3. Recording the deed. The signed deed is filed with the county's Land Records Office, ensuring it's public information and offers protection to the grantee. Deeds aren't all the same. There are different types based on specific situations. Warranty deed. This deed guarantees that the grantor owns the property and has the right to sell it. It provides the most protection for the buyer. Quitclaim deed. Used mainly between family members or in divorces, this deed transfers any ownership interest the grantor might have without any guarantees of that interest's extent. Special warranty deed. The grantor guarantees they haven't encumbered the property during their ownership, but makes no guarantees about previous owners. Navigating the landscape of property titles and deeds can be intricate, but with the right real estate lawyer by your side, the path becomes clearer. For more insights on real estate law, visit our website linked in the description. And remember, for regular legal wisdom, hit subscribe and tap that like button. A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the special needs trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a special needs trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. Improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. Joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party, or if the 2 parties were to die simultaneously. Number 2, survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. Contact Heritage Law Office today for a free case evaluation. Understanding Special Needs Trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or S&T, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are 3 main types of special needs trusts. First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential, with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. It provides financial security and enhances the quality of life for individuals with disabilities. In this video, we will explain how a charitable trust works, the benefits it offers, and the steps to establish and manage one. Charitable trusts are legal entities created to manage assets for charitable purposes. The 2 main types are charitable remainder trusts, or CRDs, and charitable lead trusts, known as CLTs. Each type serves different purposes and offers distinct benefits. A charitable remainder trust allows you to provide income to yourself or other non-charitable beneficiaries for a specified period, after which the remaining assets are transferred to the designated charity. On the other hand, a charitable lead trust provides income to the charity for a specified period. After this period ends, the remaining assets are distributed to your non-charitable beneficiaries, such as family members. Establishing a charitable trust offers numerous benefits. First, the tax benefits are significant. Donors can receive income tax deductions for the value of the assets placed in the trust, reduce estate taxes, and avoid capital gains taxes on appreciated assets. Additionally, charitable trusts support important causes, enabling you to leave a lasting legacy. They also offer financial planning flexibility, providing a steady income stream and professional asset management. Setting up a charitable trust involves several steps. First, define your philanthropic and financial goals and choose the type of trust that best suits your situation. Next, select the charitable beneficiaries and work with an attorney to draft the trust document. Transfer the assets into the trust, appoint a trustee, and obtain a tax identification number for the trust. It's essential to seek professional legal and financial advice throughout this process to ensure compliance and maximize benefits. When establishing a charitable trust, consider the type of assets you will use. Cash and securities are straightforward, but real estate and business interests may require proper valuation and management. Accurate asset valuation is crucial for tax purposes and income distribution. Selecting the right trustee is also vital. The trustee manages the trust's assets, makes income distributions, and ensures compliance with the trust terms. Choose someone experienced and reliable, or consider institutional trustees for professional management. Creating a charitable trust requires ongoing management. Regularly review the trust's performance to ensure it meets its objectives. This includes evaluating investment returns, verifying income distributions, and confirming that charitable beneficiaries use the funds as intended. Adjust the trust terms as needed to reflect changes in your circumstances or goals. Ensure continuous compliance with IRS regulations and legal requirements by consulting with your attorney and tax advisor. Establishing and managing a charitable trust can be complex, but with the right guidance, it can provide significant benefits. By taking the time to understand your objectives and carefully planning the details, you can create a charitable trust that supports the causes you care about while providing financial benefits for you and your heirs.
Thinking about how to protect your assets and make life easier for your loved ones? A revocable trust might be the answer. A revocable trust lets you transfer ownership of your assets, like your home and bank accounts, into a trust while keeping full control. You can buy, sell, or move assets in and out of the trust just like always. And since it's revocable, you can change or cancel it anytime you want. One major benefit? Avoiding probate. It's the court process that can be time-consuming and expensive when someone dies with just a will. With a revocable trust, your assets pass directly to your beneficiaries, meaning less hassle and more privacy for your loved ones. Plus, if you become incapacitated, you can name a successor trustee to manage your affairs, avoiding confusion and family conflict.
In a life estate, 2 or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. The life tenant has full control of the property during his or her lifetime and has the legal responsibility to maintain the property as well as the right to use it, rent it out, and make improvements to it. When the life tenant dies, the house will not go through probate, since at the life tenant's death the ownership will pass automatically to the holders of the remainder interest. Because the property is not included in the life tenant's probate estate, It can avoid Medicaid estate recovery in states that have not expanded the definition of estate recovery to include non-probate assets. Even if the state does place a lien on the property to recoup Medicaid costs, the lien will be for the value of the life estate, not the full value of the property. If the property is sold, the proceeds are divided up between the life tenant and the remaindermen. The shares are determined based on the life tenant's age at the time. The older the life tenant, the smaller his or her share, and the larger the share of the remaindermen. Be aware that transferring your property and retaining a life estate can trigger a Medicaid penalty period if you apply for Medicaid within 5 years of the transfer. Purchasing a life estate should not result in a transfer penalty if you buy a life estate in someone else's home, pay an appropriate amount for the property, and live in the house for more than a year. If you have any questions regarding life estates or estate planning, contact the experienced attorneys at Heritage Law Office for a free consultation.
Welcome to our comprehensive guide on estate planning. This presentation aims to provide you with essential knowledge to ensure peace of mind for you and your loved ones. Let's explore the key aspects of estate planning and how it can benefit you. Estate planning involves arranging for the management and disposal of your estate after death or incapacitation. It ensures your wishes are followed and helps minimize taxes, legal fees, and family disputes. Let's delve into why this process is crucial. Estate planning is vital as it protects your loved ones and assets. It helps avoid probate, designates guardians for minor children, and ensures healthcare decisions align with your values. Understanding these benefits is key to effective planning. An estate plan comprises several key components: a will, trusts, power of attorney, healthcare directives, beneficiary designations, and a letter of intent. Each plays a crucial role in ensuring your wishes are respected and executed properly. A will is a legal document specifying asset distribution. It appoints an executor and names guardians for children. However, it must go through probate, which can be time-consuming and costly. Understanding its role is essential in estate planning. Trusts help avoid probate and provide more control over asset distribution. They come in various types, including revocable, irrevocable, special needs, and charitable trusts. Each serves different purposes and offers unique benefits. A power of attorney, POA, appoints someone to handle financial and legal matters if you're incapacitated. A durable POA remains in effect after incapacity, ensuring your affairs are managed according to your wishes. Healthcare directives include a living will, which outlines end-of-life care preferences, and a healthcare proxy, which appoints someone to make medical decisions on your behalf. These documents ensure your healthcare wishes are respected. Beneficiary designations apply to life insurance, retirement accounts, and some bank accounts. They supersede your will, so it's crucial to keep them updated to reflect your current wishes and avoid unintended consequences. Estate taxes can significantly impact your estate's value. The federal estate tax threshold is $13.61 million as of 2025, but this is subject to change. Some states have their own taxes. Using trusts and gifting strategies can reduce tax liability. Avoid common estate planning mistakes: not having a plan, forgetting to update documents, ignoring digital assets, not considering long-term care, and choosing the wrong executor or trustee. Awareness of these pitfalls is crucial. Creating an estate plan involves several steps: taking inventory of assets and debts, identifying goals and priorities, choosing beneficiaries, drafting legal documents, and reviewing regularly. Each step is vital for a comprehensive plan. Update your estate plan during major life events: marriage, divorce, birth or adoption of a child, major asset changes, death of a family member, or changes in tax laws. Regular updates ensure your plan remains relevant and effective. Working with professionals can enhance your estate planning process. Consider consulting an estate planning attorney, financial advisor, tax professional, and trust officer. Their expertise can provide valuable insights and guidance. Final thoughts. Estate planning is not just for the wealthy. Start early and review regularly to protect what matters most, your people and your wishes. A well-crafted plan ensures peace of mind for you and your loved ones. We now open the floor for questions. For further assistance, please contact the Heritage Law Office. We're here to help you navigate the complexities of estate planning and ensure your wishes are honored.
Revocable trusts are often used to get the effects that most people are searching for when they get a will. Wills have an issue when compared to trusts in that, by law, they are routed through the probate process, which takes significant time and money. Probate is the legal process that occurs to your estate after you pass away. A properly designed and funded trust can completely avoid probate, bypassing the need for mandatory waiting periods, your information being publicly disclosed, and having the entire process monitored by a court. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. Here's how to avoid probate. If you pass away without proper pre-planning, your assets will likely go through probate. Probate is a court-supervised process for distributing your assets to your heirs. The process can be time-consuming and expensive, and it can tie up your assets for months or even years. What is probate? Probate is the legal process of distributing a deceased person's assets to their heirs. If the deceased person had a will, the court will follow the instructions in the will. If the deceased person did not have a will, the court will distribute the assets according to state law. The probate process can be time-consuming and expensive. It can also be stressful for the family members who are trying to settle the estate. The probate process can take months or even years to complete, and during that time, the assets of the estate are usually not available to the heirs. Why you should plan your estate to avoid probate. There are several good reasons to plan your estate to avoid probate. The probate process can be expensive. Probate can tie up your assets for a significant period of time. Probate is a public process, which means that anyone can access the documents filed with the court. If you don't want your assets to go through probate, you need to plan your estate carefully. There are several ways to avoid probate, including setting up a trust, transferring ownership of your assets to a beneficiary, or giving your assets away. How can you avoid probate? If you plan your estate carefully and properly, you can avoid probate altogether. One way to avoid probate is to create a trust. A trust is an arrangement in which property is held by one person, the trustee, for the benefit of another person, the beneficiary. Trusts can be used to avoid probate because the property in the trust does not go through probate when the trustor dies. Another way to avoid probate is to name a payable on death (POD) or transfer on death (TOD) beneficiary on eligible accounts. Assets that have a payable on death or transfer on death designee will not go through the probate process. Another way to avoid probate is to give away property during your lifetime. For example, you could give your assets to your children now instead of waiting until after you die. However, this may not be practical for everyone and may not have the best tax consequences for your children. Allowing your children to inherit assets allows them to benefit from a step-up in cost basis. Finally, some other estate planning tools, such as a life estate, may be available to avoid probate. There are many estate planning tools, each with their own uses. It is important to speak with an experienced estate planning attorney to find the proper tool for your individual situation. Thank you for watching this video brought to you by Heritage Law Office. If you found this information valuable and wish to learn more, don't forget to like, share, and subscribe to our channel for more insightful content.
Do you actually need a power of attorney? Or is it just something lawyers try to sell you? Here's the truth. If you become incapacitated tomorrow, who pays your bills? Who makes your medical decisions? Without a power of attorney, your family has to go to court. That process can take months and cost thousands. A power of attorney lets someone you trust step in immediately. No court, no delays. So ask yourself, do you have assets, a family, a business? Are you over 18 years old? Then yeah, you probably need one. Drop a comment if you've set yours up or tell me what's holding you back.
In our last video, we discussed funeral trusts and spend-down strategies for nursing home care and Medicaid eligibility. Today, we're going to explore an important aspect of Medicaid planning, the look-back period and potential penalties. When you apply for Medicaid, there's a financial review process called the look-back period. This is a span of 5 years during which Medicaid examines your financial transactions to ensure you haven't transferred assets solely to qualify for Medicaid. The purpose is to prevent people from giving away their money or property just to meet Medicaid's asset limits. During this 5-year window, Medicaid looks at any gifts, transfers, or sales of assets you've made. If they find that you've transferred assets for less than fair market value, these transactions may trigger penalties. For example, if you gifted a significant amount of money to a family member within the look-back period, Medicaid may impose a penalty period during which you are ineligible for benefits. Penalties for violating the look-back period rules involve a waiting time before you can receive Medicaid coverage. The length of this period depends on the amount of money or value of assets transferred. Medicaid calculates how long the amount transferred would have paid for your care, and that duration becomes your penalty period. So, how can you avoid these penalties? First, early planning is crucial. Start planning for long-term care and Medicaid well before you need it. This gives you time to arrange your finances in a way that complies with Medicaid rules. Second, be aware of the types of transactions that can trigger penalties. Large gifts, property transfers, and sales for less than market value within the look-back period can all lead to penalties. It's essential to document any transactions and understand their potential implications. Third, consider working with a qualified attorney who has experience in elder law and Medicaid planning. They can help you navigate the complex rules and develop a strategy that minimizes penalties while protecting your assets. Let's look at a couple of real-life examples. Imagine someone who transferred a large sum of money to their children 2 years before applying for Medicaid. This transfer would likely trigger a penalty period, delaying their eligibility for Medicaid benefits. On the other hand, someone who planned ahead and set up an irrevocable funeral trust 5 years in advance would have those funds exempt from the look-back review, avoiding penalties. Even if you haven't planned 5 years in advance, there are still ways to protect some of your funds. Consulting with an experienced attorney can help you explore options like partial asset protection and other strategies tailored to your specific situation. In summary, understanding the Medicaid look-back period and its penalties is vital for effective Medicaid planning. By starting early, avoiding questionable transactions, and seeking professional guidance, you can protect your assets and ensure you're prepared for future long-term care needs. Thank you for watching. If you have more questions or need personalized advice on Medicaid planning and the look-back period, consult with a qualified attorney to explore your options. To date, we're going to talk about a topic that many might overlook: funeral trusts. A funeral trust is a legal arrangement you set up in advance to cover your funeral expenses. It ensures that the money you set aside will be used specifically for your funeral costs, alleviating financial and emotional stress for your family during a difficult time. A funeral trust is a financial arrangement in which funds are set aside to pay for your future funeral and burial expenses. This trust can be revocable, meaning you can change or cancel it, or irrevocable, meaning once it's set up, it can't be altered or revoked. So why consider a funeral trust? Here are a few key benefits. Number 1, financial protection. Funeral trusts can help protect your assets from being used for other purposes. This is especially important for individuals seeking to qualify for Medicaid, as funds in an irrevocable funeral trust are typically exempt from asset limits. Number 2, peace of mind. Knowing that your funeral expenses are covered provides peace of mind for both you and your loved ones. It's one less thing for your family to worry about during a time of grief. Number 3, cost control. By setting up a funeral trust, you can lock in current prices for funeral services, protecting you from inflation and rising costs over time. Now, let's talk about how to set up a funeral trust. There are a few key steps to follow. First, consult with a professional. Work with a qualified attorney or financial advisor to understand your options and ensure the trust is set up correctly. Next, choose a funeral provider. Select a funeral home or provider and decide on the services you want. This could include everything from burial or cremation to specific types of services and merchandise. Then, fund the trust. Transfer the funds into the trust. The amount you deposit will depend on the estimated cost of your chosen funeral services. Before setting up a funeral trust, here are a few important considerations. Firstly, decide whether a revocable or irrevocable trust is best for your situation. Each has its advantages and limitations. Secondly, understand that funeral trust laws vary by state, so it's crucial to be aware of the regulations in your area. Finally, choose a reliable trustee who will manage the funds and ensure they are used appropriately when the time comes. While it's a difficult topic to think about, setting up a funeral trust is a thoughtful and practical step that can provide significant benefits. It's about planning ahead and making sure your final wishes are honored without placing a financial burden on your loved ones. Thank you for watching. If you have more questions or need guidance on setting up a funeral trust, consult with a qualified attorney to explore your options.
Life is full of surprises, new relationships, growing families, and unexpected financial windfalls. But have you ever wondered how these life events affect your last will and testament? You're not alone. Delaying the update of your will can cost you dearly, leading to potential asset disputes, loss of money, and legal headaches for your loved ones. Today, we'll make sure that doesn't happen to you. Welcome back to Heritage Law, where we simplify legal matters for your peace of mind. In this video, we'll discuss 3 very important topics for you. The process of updating a will, why it's important to keep it up to date, and common scenarios that may prompt you to make changes. Ready to secure your family's future? Let's get started. Up first, how do I change my will? To begin, a will is a legal document that outlines your wishes for the distribution of your assets and the care of any minor children after your death. But what happens when the will no longer reflects the intentions of the person who created it? There are 2 fundamental methods for updating a will if it no longer aligns with your intention. First, by drafting an entirely new will, or second, by amending the existing will with a document called a codicil. Let's explore these approaches, beginning with the first method, drafting a new will. Drafting a new will is often the favored method for updating an estate plan. However, neglecting to properly revoke the previous will may leave the new will susceptible to court challenges. To prevent such issues, it is essential to clearly revoke the old will. Here are 2 options for doing so. Option 1. Add a revocation clause. Create a new will, and within it, stipulate that you revoke all previous wills. Keep in mind, the new will must meet the same requirements as the initial one, including testamentary intent and capacity, absence of undue influence, fraud, or duress, and proper signatures and witnesses in compliance with the law. And Option 2. Revocation by destruction. Physically destroying the old will and all copies through means such as burning, shredding, or ripping out the signature. Note that this method does not permit the removal of specific provisions for change or termination. Instead, destruction through a physical act invalidates the entire will. It is still a good idea to include a revocation clause in the new will to clearly state your intentions and avoid any potential legal disputes or confusion. The second approach to modifying a will is by drafting a codicil. A codicil is a supplementary document that makes changes to an existing will. Like a regular will, codicils must show testamentary intent and satisfy all other requirements for validity. However, this method is not preferred because it leaves the person making the will with 2 legal documents. If one of them is lost, it could lead to potential challenges to the will, as codicils are not intended to serve as standalone wills. Now that you've updated your will, what should you do after? After updating your will, it's essential to take steps to secure and protect the document. just as you did with the original will. Store the original and all copies in a safe place, such as a lockbox at home or a safe deposit box at a bank. Inform the executor of the will's location. Keep the original will and its copies separate. Clearly mark copies as duplicates and include a note indicating the location of the original will, and provide a copy to a select few trusted individuals. Although you are not required to give anyone a copy, it's a good idea to leave one with the attorney who drafted the will. Have you taken any steps to secure and protect your will, and do you have any unique methods or additional precautions that you would like to share with the community? Let us know down below. And if you find this video informative and helpful, please give it a thumbs up. It really helps the channel out. Finally, our last question. When should I change my will? Estate planning is an ongoing process, and it's a good idea to revisit the terms of your will at least once a year, even if only to reaffirm them. However, certain life events may necessitate changes to your will, including divorce, marriage or remarriage, the birth of a new child, grandchild, or the addition of stepchildren, a serious and permanent falling out with a beneficiary, receiving a significant amount of property or money since your last will update, and relocating to a state with different marital property laws. Pause here for the full list. Failing to update your will after these events could lead to unintended consequences, such as assets being distributed to an ex-spouse rather than your current spouse or children, disinheriting a child or grandchild accidentally, leaving your estate to people you no longer have a relationship with, or by unintentionally excluding new family members, and a lengthy legal battle among your loved ones to determine your true intentions. Pause here again for the full list. It's crucial to keep your will up to date as your life circumstances and intentions change. Otherwise, you risk putting your family and loved ones through unnecessary stress and legal complications. Whether you choose to draft an entirely new will or amend your existing one with a codicil, it's essential to follow the proper legal procedures to ensure your wishes are honored.